Hello, everybody. Um, just getting back to last week's discussion on the Fourth Amendment, New Jersey versus TLO. All right, and that's where the young girl was suspicious activity in the bathroom, and uh, teachers, and then vice principals, and then looking at her purse and finding other contraband in there, marijuana, etc., and um, her then being expelled from school and some criminal charges against her, of course, as a minor, but that case taken to the Supreme Court. I had four questions for you last week. They were: does the Fourth Amendment apply in search of a purse? Why or why not? Should a school official be able to search a student's purse only on probable cause that something illegal might be found? Should a school official be able to search a student's purse whenever there is reasonable suspicion, which is a lesser standard than probable cause, that something illegal can be found? And then the fourth question: should a school official be able to search a student's purse, wallet, locker, whatever, only if the official has a search warrant? All right. So some of you might think that a teacher or administrator should have a search warrant, but the Supreme Court has decided differently. And I just kind of um, interject that I'll read the Supreme Court's ruling, but one of the things that happens when you're dropped off to school and parents sign a bunch of stuff is that the school, in some regards, becomes your parent, which is an interesting scenario, right? But they're there for your education and safety and the other 1,000 people plus that attend like Altoona schools. Um, so to balance between individual rights and the health, education, safety of the other persons in the building, that um, there's some leeway when dealing with students and um, minors that are in school. All right, so the Supreme Court of the United States ruled that the Fourth Amendment does apply to searches made by school officials, so you do have some protection. It further ruled that no search warrant was necessary in this case. No probable cause standard had to be met. Instead, the standard was whether the search was reasonable under the circumstances. Here, the Supreme Court upheld the search as reasonable. Basically, three questions seek to determine whether the students feel there is something about a school setting which should cause a relaxation of the Fourth Amendment. The first question was should uh, police be able to search your purse or effects? Um, and if there's reasonable cause to do so without a search warrant, yes, that can be done. But as your parent out in society having a purse, unless they're actually highly likely to be committing a crime like rob a store or suspicion of that or something, there's at no time should government be looking in your purse or your effects for no reason, just because. Ordinarily, under the Fourth Amendment, a search of a person and his or her effects would not be permitted in the absence of circumstances. Okay, lawful arrest, stop, and frisk. In response to any questions regarding TLO's right to privacy, the court's decision in this case stated that there is a right to privacy among students. However, there is a need to strike a balance between the school child's legitimate expectations of privacy and the school's equally legitimate need to maintain an environment in which learning can take place. All right. So that's the ruling in New Jersey versus TLO. and that kind of situation where the school is your parent when you're at school is kind of unique. And as time has gone past with things that happen at school and terrorism and a lot of more safety concerns as opposed to whether somebody's has contraband. And today, with vaping, this is then uh, a current event that's happening more frequently. Smoking was kind of on the downward slope, but now with vaping, it's starting to rise again. So that then brings us back to these prior court cases. All right, so the next court case, this deals with the Fifth Amendment. Moving on, and Fifth Amendment is the right to grand jury, which grand jury will look at evidence and decide as a group of up to 25 people whether there's enough evidence to bring a court case to court. And not to be tried for a case more than once. If you're found not guilty, the government cannot come back over and over and over to until they get a conviction. So government basically has one shot to arrest and have a trial and then find you guilty. And if they don't do it right, then you are basically free to go and live your life and move on. Now, if you commit another crime or similar crime, doesn't mean that you won't be convicted or tried for that crime because you were found not guilty for another crime. All right, so then you have the right to counsel and the right to remain silent under the Fifth Amendment. So one of the court cases looking at here is Miranda, Ernesto Arturo Miranda. These are his mugshots. He was arrested many times. Here he is in the lineup, number one, during one of his escapades. There, he's Dr. Minashare. Getting a call. Kind of spooky. All right, so we'll let that go. All right, so Ernesto Arturo Miranda was accused of rape in the 1960s, and he was brought to the police station and interrogated for 3-4 hours. He was not told of his right to have an attorney present or his right to remain silent. He confessed after 3 or 4 hours. He then was found guilty. His confession used in evidence against him. The Supreme Court ruled that, along with him in 3 other cases, that government needs to, police and government needs to provide notification to people that they have the right to remain silent and that they will be allowed to have an attorney. And since these things were not given to Ernesto Arturo Miranda, they remanded it down to the courts again, and they retried without the confession. He had a girlfriend he was living with at the time. She presented evidence against him that he confessed to her, physical evidence, other evidence. He was still convicted. He was sentenced to 20 to 30 years in prison. He was released on parole after 5 or 6. And he was making a little bit of a living selling Miranda cards, the ones that police read to you. You have the right to remain silent. You have the right to an attorney. If you cannot afford one will be provided for you. Do you understand these rights? Those cards that have those protections on their Miranda rights, he was signing those for $2.50, I believe, and selling those. Some police officers would get them and other people. So there might be a couple hundred to 500 of those out there that he signed. But in 1976, he was playing cards with some individuals. Argument broke out, and he was stabbed to death. The police came and, in their questioning, finding out that it was this person that likely stabbed Miranda to death. So they arrested him, gave him his Miranda rights, told him of his right to remain silent. He remained silent, did not say anything, did not give evidence against himself, and they could not get any evidence for this murder. So Miranda was buried and had no justice for his murder and never even went to trial. So, because of Miranda rights, his murderer basically got off with his murder, which is kind of ironic, if to say the least. All right, so not a good situation for Miranda, what he was up to. Not a good situation he's killed. Not a good situation that whoever killed him got away with it. But the good situation is if you or me or anybody is ever arrested for anything, we have those Miranda rights to remain silent, not to give evidence against ourselves, and to have an attorney represent us and not be tried over and over and over for a crime until they get a conviction. All right, so that's Miranda versus Arizona. The next one is Brown versus Mississippi. In the right corner there, you have the three individuals that were accused of a crime. I'll read this to you. Brown versus Mississippi, 1938. Three black persons were arrested for the murder of a white person, which occurred March 30th, 1934. So this is during segregation, Jim Crow laws, Ku Klux Klan, racism in the South, Deep South, Mississippi, before World War II during the Depression. All right, so they confessed to the murder on April 4th, 34, and were tried on April 5th and 6th, and all three were found guilty of violating state law against murder. Without their confessions, there would have been insufficient evidence to convict the defendants, and the judge would have been required to dismiss the case. Now, the crazy thing that I see here is that uh, murders on March 30th, and in a week they have a trial and they're found guilty and sentenced to death, all within 1 week. That is just mind blowing, crazy that happened that quick. All right, so on the day of the murder, one of the defendants, a man named Ellington, was taken to the home by the deputy sheriff, taken from his home by the deputy sheriff, and others to the home of the murder victim. There he was accused of a crime by a number of white men. He denied that he had committed the crime. He was hung temporarily to a tree, let down, and hung temporarily again. When he refused to confess, he was then tied to a tree and whipped. He did not confess and was released. Okay, so they're hanging him. It doesn't really say upside down or by the neck. I'm guessing by the neck, which just could break his neck doing it that way. Strong guy, not confessing. I would have confessed immediately. I'm not going to let anybody do that to me. So almost 2 days later, he was arrested for violating the state law prohibiting murder. He was whipped again by the deputy sheriff and told that he would be whipped until he confessed. He then agreed to confess. He then named two other persons in connection with the murder, Ed Brown and Henry Shields. So